Good afternoon, everyone. My name is Baldev Binder. Welcome to our Blackstone and Gold webinar today on asset recovery, asset diversion, fraud, dissipation, all our favorite words that we see in our work. Today, we're joined by guest speakers that we have. I'm very pleased to have Reshmi Karuna from Kroll and also Jayesh Katlani from the offshore law firm Harneys. I have my colleague Kumar, who was on the camera a second ago but has disappeared since, but I think he will come there in a second or two. While we're waiting for Kumar, Reshmi, Jayesh, thanks for joining us. Let's start. Let's give some background to the conversation that we want to have, and I think fraud and dissipation and diversion means 100 different things to different people at the same time. I think the stats are quite interesting, and we've pulled up some numbers for what the level of scams that have been going on in Singapore alone. We have seen in Singapore scam victims losing, I believe, $600 million in 2022. Cases have been going up 30%. Phishing scams are particularly notorious, and there's a lot of investment scams that go about. I think this is best captured by what went on with NB Asset Management. And then for those who don't know, it's in the press in Singapore. And NB Asset Management is a case that's going on in the court in Singapore for prosecution and the like. And the basic story about that is very much a Ponzi scheme. And I think a company was set up promising fantastic yields of 15% per quarter. And a lot of investors, fairly sophisticated investors, invest in this scheme. And it must have been going for some time, I think, between October 2017 till sometime in 2021 for a few years. And as all Ponzi schemes are, they will unravel, and this one unraveled as well. And it turned out that the scheme, which was predicated on trading of nickel contracts that this company, NB Asset, claimed to have gotten a receivables deal from one of the big nickel traders, and they were generating such high returns, turned out to be all a bunch of hogwash. Nothing was there. There was no trades, and in the end, the loss figures actually were staggering. The point that we want to raise very simply is $700 million was paid by investors, of which only a fraction of it has been recovered back. And now there's a question as to where that money has gone to, which is, pardon the pun, the million-dollar question after all. Where has the money gone to in this whole Ponzi scheme? You have to remember, the thing about Ponzi schemes is that it's all going to come to an end, and the person perpetrating it will know this as well. They're not going to do it indefinitely. There is a plan on which to hive off assets and divert assets and so on at that time. And so the question is, of course, much of it is being able to spot the red flags, but when it's hit the fan, what do we do in terms of asset recovery, and how best do we go about it, getting asset recovery? So before I turn to our speakers, maybe the first question I'll ask for Kumar, if he's controlling the slides, Kumar, is to give us a bit of a flavor of the different fact patterns that might come about in a fraud case. What steps does a victim broadly have? And I think you have up on the screen some of the patterns. Kumar, I'll hand the floor over to you.
Thanks a lot, Baldev. Happy to be here. Good to see you guys too, Jayesh and Reshmi. Thanks for joining us. So a typical fact pattern is where a fraudster perpetrates this scam or scheme to defraud victims of monies. Victims end up depositing their hard-earned money into this bank account, usually owned and controlled by the fraudster. The bank account could be in any jurisdiction. Sometimes it's in an offshore one, and that's where things get a bit exciting for Jayesh, I'm sure, because expertise is in the BVI. So once that happens, the fraudster then applies that misappropriated monies towards several different things. Either he transfers those monies to third parties, maybe he sends it to his family members to hold on his behalf, uses those monies to purchase assets that he himself intends to enjoy. Sometimes, in very, very limited circumstances, perhaps he uses that money to repay a debt as well. That gives rise to certain interesting rights that victims may have to pursue those monies. So in this context, what can victims do? Broadly, there are four sort of key things that happen at the same time, depending on the facts. If the fraudster is known, right, it's an investment scheme. Someone promised incredible returns, you paid him money, and it all just didn't materialize. The fraudster is known, you can pursue the fraudster directly. There are several causes of action against the fraudster to pursue recovery against that person. But when the fraudster is not known, right, then you need to start taking out disclosure applications against the third parties who have that information. Information relating to the fraudster's identity, the identities of third-party recipients, and where the monies went to. And that's where victims can apply for disclosure orders, Norwich, Pharmaca, and Bankers Trust orders, which we'll speak about in the course of this Q&A. And on top of that, so we've got action against the fraudster, we've got disclosure orders. At the same time, victims can also take out injunctions, freezing injunctions, or proprietary injunctions, where you can assert an interest or property right over those assets. Then you're able to ring fence that property so that you can prevent the further dissipation of those assets to third parties. Finally, once all of that is done, if the victim still can't obtain relief or recovery of those assets, then the victim has to start looking to the third party recipients of those misappropriated funds. And that's when we try to pursue them on various bases. Knowing receipt, that they knowingly received monies breach of trust, and we talk about that. And where it's clear that assets have been purchased, for example, using those misappropriated funds. So broadly speaking, those are the four areas that happens concurrently, in my view. Olive, sorry, you're muted.
The good old mic. Yes, guys, you have these four situations. So you have where the fraudster is known, fraudster is not known. You've got disclosure orders, you've got freezing orders, and then you've got third parties. What do we do with all these third parties, whether they're innocent or not? Kumar, maybe for the benefit of the audience, I think when people talk about tracing what money they lost, because if I can give you $1,000 today, I somehow might think that I'm given a legitimate right to get that $1,000 back. No matter where it's gone to, I'm entitled to my $1,000. And obviously there might be a few hurdles and obstacles towards that. What sort of tools does the law allow in terms of tracing money or assets that's moved to different jurisdictions and different people?
Sure. So tracing isn't a cause of action per se. It's sort of it's a process, right? And you're asking the court to assist with this process of following the money. And the two really common sort of premise or way to establish this or to seek this remedy of tracing. The first is where there's a breach of fiduciary duty. So what is a fiduciary? A fiduciary is someone who owes you an obligation of trust, an obligation to act in your interests. And it arises in situations where there's trust and confidence that that person will do a particular thing. And the law recognizes certain accepted categories of fiduciaries: trustee beneficiaries, partners in a partnership, directors, etc. So where there's a breach of fiduciary duty, that person doesn't act in your interests, takes the money, runs away. In those circumstances, the law imposes a constructive trust over those assets that have been misappropriated, and that sort of forms the basis for you to seek that tracing sort of remedy to follow the money. The other sort of related cause of action is a proprietary claim, and it's related in the sense that usually it's the same fact pattern, but the reasoning is slightly different. So in this case, for a proprietary claim, it's where monies have been dishonestly misappropriated without the victim's consent, and then the law sort of imposes a constructive trust and also entitles you to that remedy to follow the money. So that's in a nutshell the sort of reasoning that victims need to put forth in trying to convince the court to grant them.
What if the money goes to a third party? What happens then?
So if the money goes to a third party and you've identified the third party, then we start trying to figure out whether or not we're able to get that third party to pay, right? And in the situation where the third party is in knowing receipt of those funds, so there are a few elements to this. First, and the key one is that that third party must have known that he's received monies in breach of a fiduciary duty, such that it's unconscionable for him to retain the benefit of those monies. I know this is a lot of legal jargon going on here, but basically it doesn't make commercial sense for that third party to keep the money. And I'll just give you an example. There was this famous lawyer in the past, David Rossif. He stole his client's monies. He used a check, went to a jeweler, gave that check to the jeweler, and that check had the words client's account written on it, right? And so obviously the victims were saying, obviously you should have known that a lawyer shouldn't be using his client's monies to buy jewelry. It was for $270,000. And the court used that reasoning that in the context in which that person received the check, it's unconscionable because that person ought to have known that a lawyer wouldn't use his client's monies to buy jewelry, and so that third party was liable to account. So that's one example of the sort of reasoning that victims have to rely on to try and get third parties to account for monies that they receive.
Understood. So it seems to be knowledge to be quite a key factor. But Rishmi, if I could come to you in that part, all these tools the law gives you, it imposes a condition of knowledge that all the different actors must know each other, or they must have received the money knowing, or they must have received this assets or money knowing it's not theirs in the first place, or knowing that they're not entitled to it. And that boils down to the ultimate question of who is this third party? How are they connected with the fraudster and his accomplices and so on? Are they accomplices? And often I think that's where the skill sets of a company like Kroll will come in terms of mapping out some of the relationships that have gone on. And when you've got the relationships, then you might get knowledge. But you need to have the relationships first, yeah?
Absolutely. Thanks for that question. And as an investigations firm, that's exactly why we are brought in. And I think it's becoming increasingly relevant in today's environment because a lot of fraud is happening across jurisdictions, right? So often monies are flowing across borders. They're flowing around the world. And the third parties could be located anywhere. And hence sort of having that additional information on who are these third parties. So, the parties in dispute might be in Singapore, but where the money has dissipated to, for example, could be anywhere in the world. And hence having that additional information on who these parties are, how they're related to each other, absolutely is very critical. We recently did a case where, we were working for a law firm like yours that was representing a client, that had entered a contract to buy a financial asset, and they had made the money, paid the money, and the money had flown, to various parties over sort of 36 parties, which because of the disclosure orders, they were able to learn the names of these parties, which is, a very good first step. But they had to go much beyond that because there was an indication of, are these parties real? Is there an element of actually identity theft here? So some parties were presented in a certain way, but the client wasn't even sure if these were the real parties. What was their role? Because that was then going to determine the extent to which they were going to internationalize this dispute, right? And the amount of resources they were going to spend and which countries to focus on. So that's one example. So whether you're tracing a financial instrument, or coal or crypto, we trace all sorts of assets. The fundamental question, as you rightly said, is who are these people? What's their relationship between each other to drive your recovery strategy, essentially?
Yes, and I often find it's a judgment call, right? You'll have to decide how much information you have before you go and launch with all the legal tools and all the knives and guns that we use to get the information. But because you can it's not one layer, like every corporate map that you draw, there's going to be a holding company above that, another company, and it all boils down to the mystery of the BVI. And that's where I think I want to ask Jayesh more about the BVI. The BVI has a good and bad reputation, I think, depending on which side of the fence you sit on. Some people look at it as a very opaque place where billionaires and oligarchs put their money in all sorts of offshore companies for the very purpose of not being able to be discovered. I wanted to, before we talk about freezing injunctions and what to do, I think the first question is obviously, how do we find out who these people are? And in some instances, you get Reshmi doing that mapping out exercise, and sometimes you hit a bit of a brick wall. You get a BVI company and nothing else. Then I guess they pick up the phone and they call you, and where do we go from there, Jayesh?
Thanks, Baldev and Kumar and Reshmi. That was actually a really helpful sort of summary of things that we deal with at Harneys sort of daily. And you're right, Baldev. The nature of what we do and how people think of BVI Cayman companies as well is that they're opaque and that you hit this brick wall. But what I'm pleased to say is that there are these tools available. I like to call our jurisdictions, rather than opaque, I would prefer to use the word privacy friendly, and there is nothing wrong with privacy. You're always entitled to that. And it's not as opaque as people think, because for the very bad actions that you've both described, or all three of you have described, the BVI as a good corporate citizen or a good sort of jurisdictional citizen, it has their tools to address those. So with that said, when somebody comes to me and they say, gosh, we've done this search and we think that the money that has been embezzled out of our corporate entity, or has been stolen or misappropriated, or otherwise the proceeds of crime or theft, what do I do? And we've hit this BVI company. The first thing I would say is, well, have you tried running a company search? And it sounds trite, it sounds basic, and I don't think you'll get the same level of detail as you will get from an ACRA search, for example. But you will have certain things that are available. For example, in the BVI and in the Cayman Islands, and it's a relatively recent development in response to being to respond to its need to be a good citizen in the global stage. You can now find out, for example, the current directors of both of these in both jurisdictions.
Anyone can do this, Jayesh?
Yes, that's right. Which may come as a surprise to some people, because had you called me a year ago and asked me about a BVI company, I wouldn't have presented this to you, because that's a relatively new tool that's available now. But of course, it's not a perfect tool. You won't see previous directors, and directors have had notice. So maybe people have entered into nominee arrangements and things like that. You still need more. And in those cases, we go back to what Kumar was talking about as to, well, do you apply for a Norwich Pharmacal order? And a Norwich Pharmacal, in its most basic, is an order against a third party who has the information or documentation that you need in order to identify a wrongdoer. So, in fact, sorry, I've seen that you've got the company search slide. That's perfect. I thought that would be a good sample, and you'll see the copyright stamp that it says 2021. That's what you would have gotten in the past. Now you can run a separate search, and it'll give you. It's a very simple search. It'll just tell you the current directors as well. In a BVI company, now that we have the search up, you'll be able to identify all of the details that's in the next slide. But what I often find the most useful, and sometimes overlooked, is the register of charges. A lot of times there are charges registered against these BVI companies. They've given security either to lenders or even as part of the sort of round tripping type frauds that you've described with the nickel scam, the NV scam. And in those circumstances, you actually might get a useful lead just through a register of charges. So it's always worth doing, because it's an inexpensive tool and that you can get some information from. But when you hit that roadblock and you can say, this is not enough, I need to find out what the custodians, the gatekeepers actually have in their private shells locked up on the Caribbean islands. Then you go to, then I'm afraid the only way to do that, you'll have to apply to court. But the court is very, very pragmatic on these things. You can apply for that Norwich Pharmacal order that we just talked about. That will be typically in the BVI, and in Cayman Islands, it's against the registered agent or the corporate services provider, respectively. Because they will have details of the UBO. They have very, very stringent KYC, AML you will
I think
know
you
and
froze for.
expect.
Oh, you back.
Oh, sorry. I don't know if you could hear me, but I was
Perfect.
just perfectly great. So you would apply for on an Orange Pharmacal for that. That's actually a relatively straightforward process, and it's something that we commonly do in the offshore courts. I know in some of the you know, perhaps if you do apply to that in an onshore court, you might find a little bit more of a hurdle because the court will say, well, hang on, do you really need this to identify the wrongdoer because you have all of these other access to information? In the BVI in the Cayman Islands, you don't have that, and the court is very, very pragmatic about these things. So it just tends to be that, you know, coming at it from with an offshore lens, the court is quite readily to give you that sort of information if you have a bona fide sort of claim. You know, it's an ex parte application. And you'll get your Norwich Pharmacal order, which you then serve on the registered agent, who then has no option but to comply. Had you done that without having that sort of level of access, even if you were a director or a shareholder, but if you weren't the client of record, you would face the same roadblock. And that's a typical issue that, you know, I think Reshmi will and her colleagues will probably have faced this, but even if you are a office holder appointed by a foreign court, you might face that same roadblock from a registered agent. So it's a very sort of gatekeeping type role that can easily be thwarted or overcome by an Orange Pharmacal application.
And
The,
what do
the,
they? What do you get the registered agent to tell you? What level of information do you get from that? Yeah.
Yeah, well, as a starting point, you'll find out the ultimate beneficial owner of a company, which is probably the things that most people are interested in. It's what will link you to the knowing receipt claim or the conspiracy claim that you probably have in your onshore court. If you were on an asset tracing exercise, it'll probably link you to other assets that are held in those UBO's names, or perhaps you even find a real UBO. Maybe you were thinking you were dealing with a nominee all along, which has happened in a case that I was dealing with, thinking that somebody was their UBO, but actually they were mayor nominee, and then we found out really who was controlling it. So that level of information is quite helpful. You will also be able to find, as long as they've kept their records properly, you'll be able to get access to all of typically the books and records, resolutions. The requirement in the BVI, for example, is that a company is required to either file with their registered agent a copy of all of their transactions, or at least a summary of the transactions, so that you can see the business affairs that the company has conducted over a period of the immediate preceding 5 years. Sometimes you will find that, but more often than not, they will hold that sort of information onshore with either another service provider or in their own offices, but it gives you that lead to then further asset trace for those documents, the round-tripping type of documents that you will have seen in NV and those sorts of things, which can always be a great lead for an onshore, you know, as a facilitator to an onshore tracing exercise.
And I can vouch for that. You know, we did an investigation, Jayesh, where we pulled out the articles of association of a party that we knew we were trying to prove as a related party from 1985. It was we were trying to prove two parties are related, and the incorporation documents from 1985 had the name which was the wife of the defaulter for a large bank that had used us, and that became a very key sort of jumping point for us to then try and work with the legal advisors to, you know, take whatever action was needed to drive it forward. And you know, and the third party's claim was, well, you know, it was at one point owned. When you're in the same industry, you start many companies and there's lots of M&A transaction, and now it's third party. But, you know, if you have a multi-$100 million receivable, which we're trying to prove is just a round tripping arrangement, and your wife's name is on the name of your party that owes you that money, that's quite damning. So
that is
Not
quite
very sophisticated, yeah, to have your wife's name as the. Yeah, you didn't put too much thought into that. But you'd be amazed at the level of. Often people we do all this fraud work, and people often think it's some, you know, really well thought of, contrived scheme, and often it's actually just day to day. They're just going about on their day to day basis, just, you know, hand to mouth sort of situation. Just trying to get more financing to pay off other guys. That's really I think we often give them far more credit than they deserve, some of these fraudsters. So Jayesh, you're talking about the Norwich Pharmacal, and for the benefit of the audience, lawyers love using strange words that no one seems to understand. A Norwich Pharmacal is a disclosure order that you go and you give to a third party saying, tell me who owns the company or tell me who owns the bank account. In bank accounts in particular are very useful because for scams and the like, wherever there is a point of entry, there must be a point, sorry, wherever there's a point of exit, I mean, it leaves the fraudster, it has to enter somewhere else. And it enters into another bank account, just a bunch of digits. And that's where the disclosure order comes in useful because it puts a face to, or puts a name to that bank account. Kumar, I want to come to you on freezing injunction. So let's say, actually, before I do, let's go back to Reshmi, I think. And this is a question of strategy, because you've got, let's say you get the disclosure orders. It's limited in some ways because you don't get all the information that you want to get. It's still pretty hard going. Do you have some examples or some thoughts as to how you go about, if you have to go outside of the legal process, and how do you go about trying to join the dots? So is it a lot of searching, a lot of speaking to people on the ground, a lot of internet searches, social media searches, people doing stupid things and leaving their footprint there? Okay.
All of the above. And actually, well, they've increasingly, clients are now doing this even before they go down, like you said, throw all their weapons at this asset search or litigation strategy. Often they want to assess how much is out there before they decide how many resources to put, in a perfect world, they would go after this, but it depends on the scale of the fraud, the amount of the receivable, how much they think arbitration is going to cost or litigation is going to cost, so on and so forth. So often they will do this outside-in investigation of the assets before they even seek disclosure orders and so on and so forth. And that can be very useful because it can give you a good picture and help drive your strategy. Second, it can tell you, what else to bring in. So often you may be going after, say, the individual or the company who's a defaulter or your third party. But we can often sort of include, say, family members, related companies, personal investment vehicles, which can then add to the leverage that your client may have against the counterparty. So again, if you're going to the BVI with just, one holding company versus that, oh my God, this is their family investment strategy and they've got these various other things, then you maybe, can get the authorities to get more active. You can put more resources in there. And absolutely, there is a lot of, good old-fashioned investigation and fact-finding, everything from using sophisticated databases these days that use API technology to pull corporate information. So just, there are now proprietary databases we have that we can put in a name, Reshmi Khurana, and it'll show you all the companies' addresses, social media profiles that I'm linked to globally. So, 10 years ago when we did this, we would have to go, okay, what am I doing in India? What am I doing in Singapore? What am I doing in the UK? Now can all be pulled together. Social media profiles, absolutely. The dark web, people deal in, cryptocurrency. So if you've got sort of a pet project, whether you like dealing in art or crypto or some other exotic instruments, there are forums for that. And that can be a good way to sort of sweep what's available. So, we still talk about one case where we identified a boat on someone's Instagram profile because their son or daughter, I forget, was posing, there was a selfie and there was a nice boat in the back that we could then sort of zoom into and do lots of funky stuff to then identify the vehicle and the location. So yes, it's possible.
Yeah, I can't imagine them being very happy with their children then, if that's the case, letting loose the boat. Kumar, to come to you, if let's say you go down the disclosure route, you got what you got in terms of the information that you have to take the next step. Now, obviously, you are in this situation because the person that you're dealing with has, lack of a better term, defrauded you. There's no other, typically that's the way it happens. And so if he's defrauded you once, there's every likelihood that the person, is going to be a bit of a slippery character and will want to move assets out as soon as he thinks that the heat is on him or on the heat on his family. The law provides this idea of a freezing injunction, and I want to sort of talk through it. People often have misconceptions as to its use and its limitations, in particular its limitations. And the key point being that when you're chasing after for recovery, it is very seldom that you are the only one chasing. You are one of a series of creditors chasing. And where does the freezing injunction, or how does the freezing injunction help you where you are one of a queue of people chasing after for your money?
Yeah, I mean, so fundamentals, right? The injunction is meant to operate such that third parties or anyone who's mixed up with those assets are prohibited from dealing with those assets. So the threshold questions, if you're applying for an injunction, is whether or not you've got a good arguable case against the fraudster, and second, whether or not there's a real risk that the fraudster will dissipate its assets. And usually in this type of fact pattern, these requirements are met because that risk of dissipation has already been demonstrated by the fraudster. And if you're seeking an injunction worldwide, then of course one of the key criteria is that there are insufficient assets in this jurisdiction to satisfy any judgment. But I think where the law really pushes the limit even further is where injunctions can be obtained against persons unknown. In other words, third-party recipients whose identities are unknown, but they may have a relationship with the transactions. And so the requirement of identifying these unknown persons is that you should be able to define these unknown persons such that there's a category of people who are clearly part of the transaction and a category that's clearly outside. So using a recent crypto case, for example, CLM versus CLN, I believe. So in that case, this person's unknown was identified as the exchange and other parties related to the exchange that had dealt with the transaction, and everyone else who falls outside of that no longer were subject to that injunction. So broadly speaking, you have that tool at least to say that, okay, I've got an injunction. Once I've identified the third parties, then I can seek to enforce that injunction against them.
Okay. The trouble with injunctions, everyone loves using it. They're like, going to freeze. I found the boat. I'm going to freeze the boat. I'm going to go there, freeze the boat. The boat is mine. And that's the fallacy. The boat is mine. Just because you've frozen it doesn't make it yours. You're freezing it for the benefit of all the creditors. And you might rank very low in the pecking order. There might be other guys who come in. And this is the perennial catch-22 with freezing injunctions. We act for a lot of lenders, and they typically want to, before they want to, and this is interesting, Rashmi, because before they go after the bad guys, they actually want to know the level of exposure as well, because they want to know who are the other creditors and whether that's going to be worth their money as well. Because think about it, freezing injunction is an expensive exercise. It's not something you do for a couple of $1,000s. It's actually an expensive exercise. And if your claim is, let's say you've lost 10 million, but yet there's a couple of other creditors over there with hundreds of millions, then who should bear that cost of it? So that's all very strategic in terms of who goes for the freezing injunction. Often it's the person that feels the most aggrieved, but the most aggrieved is not always the person that has lost the most money, I think.
Baldev,
so
I always got the impression that, at least from Jayesh, my discussions with Jayesh, that it might be easier to get a freezing injunction in the BVI. Jayesh, do you have any thoughts on that?
Yeah, no, I'm happy to sort of chime in on it. Again, it's something that's quite regular for us. I wouldn't necessarily say it's easier, to be honest, because it is more or less the same test as you would apply over in Singapore and the UK. It's that common law, American cyanamid type of test. But I think where you see it happening more in the BVI or even in the Cayman Islands is just the nature of the sorts of disputes that you see there, where they tend to be higher value, because Baldev is absolutely right. They're really not very cheap, and they, so there has to be some sort of, it has to be worth people's while to do it. A lot of times it's not really because of defrauding, a breach of contract or anything like that. When there's a risk of dissipation that relates to a BVI company, it's because they've demonstrably dissipated is or shown that they will dissipate those assets. So you still have to meet the test. But the nature of those companies is just that once you see an asset that belonged to a BVI company or the underlying asset, it might be, typically you'll see, a BVI company that might own a Singapore company that might own an asset in Indonesia or somewhere else in the ASEAN region. And if you see that sort of thing, then and somebody's, then tried to sell the one of the Indonesian properties or assets or something like that, then that's a very good basis for dissipation. You'd go off to the BVI and get your orders. I think where it becomes a little bit easier is because a lot of the claims that we tend to see, or certainly that I've seen, they tend to be proprietary in nature, and it's because it's usually the bad guy UBO who's in control. So he's using his corporate vehicle as just an extension of himself. It's just his personal investment vehicle. In which case, the court is more ready to grant that. You can more easily impute the dissipation activities of the fraudster in the onshore jurisdiction to his BVI company, which is why the Norwich Pharmacal and things like that, just being able to link the two things are quite important.
Just one point.
Yeah.
Just one point. I think that when you go to a Singapore court, at least, and try to get an injunction, you need to peg it with an existing claim as well. You must have a claim, right? Yes. So you are rushing to file this writ, your claim against a fraudster. At the same time, you're asking the court, please give me an injunction. But I believe in the BVI, you don't need that, and I found that quite interesting. That you don't need to mount a claim. It's a freestanding injunction, which makes a lawyer's life a lot easier.
Yes, yeah, no, quite right. I take for granted sometimes that the other jurisdictions, of course, you're right, Singapore doesn't have the freestanding injunctions. And it was a controversy even in the BVI for a short while, because we used a common law basis to grant this before it got codified into law. And there was a whole lot of issue. There was a case called Black Swan, which allowed the common law injunction in support of foreign proceedings or arbitration proceedings. But then, a whole bunch of issues came on that case. Court of Appeal overturned it, all sorts of things. But what it meant is that the BVI jurisdiction very quickly had to codify it, put it into law, and now we have our legislation that basically says you can get your injunction in aid of foreign proceedings. But so you're absolutely right. You could bring a Singapore proceeding and have a BVI injunction and disclosure order, actually.
I think that makes a technical difference, quite a significant tactical difference as well, because typically you house your injunction together with your main claim. Certain jurisdictions are more friendly for doing so. Certain jurisdictions more advantageous because the assets are there. It could be many different considerations for that. I want to go back on the boat analogy because I like it. I like this idea of people drinking crystal on the boat and getting caught for doing so. So on the boat analogy, so we take a step back. You're a victim of a scam. You lost some money. That money's gone. That you've been defrauded money by person X. Person X has then sent that money across to a bank account somewhere. That bank account somewhere has then been used. Those funds have been used to purchase a boat. But that boat was purchased by funds that you've lost, but also other funds as well. So there's a commingling of money. So when you show up and you say, I've lost $1 million, I want that whole boat. How do the legal presumptions work in that, in terms of looking at who gets what, all the different creditors? Because even the fraudster might put his hand up and say, that boat was my legitimate money. I bought it from my parents' inheritance that they gave me years ago. They could legitimately say that as well. So Kumar, to you on that question, what presumptions are there in law? And then Reshmi, I'll come to you later on the extra law part. What can be done outside of the law?
You're absolutely right. Like sometimes looking at these accounts, it's impossible to distinguish between monies that belong to the victim and what monies were actually used to purchase properties. And so I think broadly speaking, there are three presumptions. In a situation where there's a maelstrom, right? There's so many transactions, there's a flurry of activity. You can't distinguish between what belongs to the victim, what belongs to the fraudster. There are three primary presumptions that the law can impose to favor the victim, right? So the first one is that all the monies that are present in the fraudster's bank account are subject to a trust. So the victim can technically assert that actually everything in the account, I have an interest over it, given the circumstances. The second sort of presumption is where, let's say, there's commingled funds in the bank account, and that money is used to purchase the boat, right? The critical boat. The first presumption is that it is the fraudsters' money that was used to buy the boat, and therefore everything that's left in the bank account is the victim's. Right. So this is one presumption that a victim can rely on to say,
What
hey,
if there are multiple victims? What if
Sorry?
you are a victim of 1,000 and there's another victim who's a victim of 1 million?
Yeah.
Both
So
of that money was used for 1,000 and a $1,001 boat.
So there are presumptions where the victims will share the gains and losses out of these fraudulent transactions in equal proportions. So if it's 1,000 to 1 million, ultimately you get a boat. You realize that asset, it'll be 1,000 to 1 million. Just to simplify matters, that presumption exists as well. But going back to that one presumption where bank account, monies buy the boat, and you can go after whatever is in the account. The flip side is also true, right? So there's another presumption where you've got a bank account, monies are used to buy the boat, and there's a presumption that the boat was purchased using the victim's monies, right? So these presumptions are actually contradictory, and ultimately, the victim has to bear in mind that these are only presumptions. At the end of the day, the fraudster has every right to, as you say, stand up and say, no, actually, that's not what happened, and then dispute the allocation accordingly. But that's how the law sort of imposes these evidentiary presumptions to assist victims in asserting a right over monies in the bank account or purchased assets.
Okay. Rishmi, the question I have is not so much on legal presumptions and the like, but I suppose when you have identified assets and assets are held within the names of family members, for example, how do you use that as leverage?
Yeah, I mean, firstly, it could, one of the reasons why we go after personal assets, especially in financial transactions and especially for banks when they have a case of default, and we are entering a difficult financial period and we may see that. We've already seen that in Indonesia, India, and, it comes in waves. Often the borrower, may be a legal entity, but the sort of, owner, the principal owner, whether it's called promoter or principal shareholder, may provide a personal guarantee. And often a personal guarantee means all their personal assets in their name, are now sort of, can be looked at. So that's where a personal asset, whether it's a boat or land or an apartment you've bought for your child who's studying in another country, all becomes interesting. So that's one scenario in which we go beyond just corporate assets and strictly the assets of the counterparty and look beyond when there's a personal guarantee involved. But yes, absolutely. The other reason is looking for other leverage, right? And that could be assets of family members and their own assets which are beyond the purview of the dispute, so that you can get someone on the table and tell them that this is what you know, and these are the things you're willing to do to bring this in. But sometimes it's also not just the assets, it's just additional information on related businesses. I mean, it's just, again, dispute management strategy, right? It could be, I found an asset, we found horse farms. You're just talking about boats, but it can get quite exotic. And hey, it's because you actually are putting up this factory in this country, and it's this other business, and hence, by the way, I can get the tax guys after you, or I can work with the regulators to put this leverage on you. So it's always that additional information and context that could be helpful. So knowing whether their family members own assets could help you, because that could mean, okay, they overall have the wherewithal to pay. They just don't hold these assets. So that could mean another discussion. Or it could be, well, let me try and find out what the motivation is to hold the assets in a certain way. So this whole area of sort of additional intelligence, whether it's before the legal strategy or after the legal strategy, can help you drive, how you're going to deal with the counterparty.
Absolutely. I would actually go further to say that I think it's, from my experience, that is more useful or more efficient or effective in getting a result than going through the whole legal hoo-ha and getting a judgment and trying to enforce it and all that sort of stuff. Because ultimately, these guys who do these things, they are in the business of covering their tracks. What you are exposed to is often the tip of the iceberg of a much larger machine at work and far more devious actions and skeletons in the closets and things like that. And the moment you show them that you have gone and taken the trouble, incurred the expense of actually finding out their entire cupboard, put it that way, I think then they start getting worried. And the ultimate question, the one that gets you a result, is always when the person you're dealing with asks themselves whether that's worth the trouble, whether paying you is better off than the trouble that they are going to face in terms of more information about that getting exposed. I mean, it's no wonder when you read the Financial Times, you can see that in action already. Of course, there's an interest element towards it with all the media reports as well. But once more and more information gets out, that's real pressure being put onto the person who has the spotlight on them. I wanted to ask you guys on your personal experiences in different jurisdictions. I think it's a bit more limited for Jayesh, but there's some jurisdictions where you find things easier to do, whether it's an investigation, whether it's getting the support of the courts. And in some jurisdictions, I suppose it might be harder. I think there's little point in talking about jurisdictions where it's difficult. Maybe it'd be better to talk about jurisdictions where you found more success, more easier to do on-the-ground investigation, or where the system is more transparent in terms of giving you information. Rashmi, I think we'll go back with you and then on the Singapore side with Kumar, and then back to Jayesh.
Sure. Yes, I mean, and that's, something we often work closely with the client to advise them on where they should start, because, we can't search in all, 200 countries at the same time. Sometimes the client doesn't even know where to go. So doing some sort of initial research to understand, it's a combination of where the assets are likely to be and where it's going to be easy to recover. So you have to sort of, do that balance. Some are very clear that, okay, if the assets are in Thailand, look, listen, I'm not interested, or Indonesia, just I'm not. But equally, there are other types of clients who have, been active in Indonesia for 20 years, and they'll say, yeah, let's find the assets. And you know what? I don't even have to worry about the court system. I'll just bring a bankruptcy procedure against them, right? I'll use other regulatory tools to drive them to the negotiation table. So that's a factor, sort of the client's DNA and experience and exposure and willingness to go. That's one aspect as well. The second aspect is, the counterparties. We touched on it in the previous question. There are counterparties for whom reputation will be an issue. And hence, when you find this additional intelligence, it could bring them to the table, which is where the question of what's driving this behavior, right? And what's their motivation to settle with you is important to understand, because I've also dealt with defaulters who will literally say, you can even put me in jail. I'll do a year of jail time. And I'm not exaggerating, sort of large, again, multi-billion, multi-hundred defaulters who've already sort of taken the benefit of the crime and protected themselves and will go to any extent to prevent that. And hence understanding the motivation. And then, as you said, another aspect is what's a friendly jurisdiction? And I mean, those are the ones, we all know about Singapore, Australia, Hong Kong, the US. Those are the ones we start with. But, for example, UAE, property records are available. We can find them if we look. It's sometimes painful. You have to go to physical registries and so on and so forth. You can get it. But, whereas, as in Singapore, you can't just search someone's name and figure out what they own. So different countries have their own nuances about what's available and what's not. But yes, typically we will start with a combination of these three: understanding the client's appetite and experience, understanding the counterparty, what's driving this dispute, and how much have you talked to them, and how much do you know about their psyche, and then which countries and which assets to go after.
That's very true. I think I like the point you raised about bankruptcy. I find that to be quite effective, and that's a good telltale sign as well, because if they're willing to become bankrupt, then I think you're in for a different fight as well. They've already stashed it quite. Then you know their level of pain is a bit more hardy. They can deal with a bit more pain. And in Indonesia, for example, they've got something called the PKPU, which is put a company into insolvency. Fairly straightforward procedure. Most insolvency/bankruptcy procedures are that way. In Singapore, Kumar, maybe you want to elaborate on that in terms of personal experiences when using insolvency and bankruptcy.
Yeah, I mean, of course, Singapore is very strong jurisdiction. Of course, the frameworks are in place, and really, in my experience, is how sophisticated the fraudster is. So we've got one method currently where the fraudster is deliberately trying to bankrupt himself, right? And he's parked his assets with his wife and other family members, and so the recovery exercise has to become a lot more creative. And trying to establish liability on the part of all these other third parties and pursuing them instead. Because going after the fraudster itself, the threshold is just far too high and will result in too much unnecessary costs incurred. So it's really identifying the path of least resistance in getting recovery. I think that's really an important part. And most of the time, for some reason, the fraudster doesn't end up in Singapore. There's always some other jurisdiction involved, whether it's China, or parties in the Marshall Islands or in Indonesia as well. And so I think in circumstances like that, it really is dependent on the frameworks available in those jurisdictions. And of course, in most jurisdictions where big banks are concerned and monies are parked there, there's less of an issue, in my view. But yeah, overall,
okay.
Yeah.
If I could come to Judge, and this is a bit more, it's a amended question of the ones I've asked before, and it's still more on insolvency and restructuring, and the BVI in particular, because sometimes the only way you're going to get information is to put the company or put the person into an insolvent state, and then you get to actually sit in the company and figure out what exactly has happened. How's the BVI experience for that? In Singapore, I can share what we do sometimes. When we put the company into insolvency, we find that no one knows where the books are. Everyone's a bit lost. The whole thing has been in disarray, and it feels to a lot of lenders sometimes. It feels like not the best use of money, not the most effective way of going about it, and sometimes they get colored that way. And I wonder whether you have the same or different experiences with the BVI.
Yeah, I mean that's a really good question, actually. I mean and you're absolutely right. Sometimes the path of least resistance is actually just to put the company into a liquidation process or even a provisional liquidation process. The rationale for that, of course, is that, as you say, it puts you directly in the shoes of the company. But don't forget, you also get the entire panoply of powers that are available in the relevant insolvency legislation. In the BVI, we have the Insolvency Act. And those powers are quite great. So even when it comes to, you'll get the books and records, and you'll get the registered agent's cooperation by the time that you've got your court order as a liquidator. Of course you will. But for example, you'll have the powers to then drill down into subsidiary companies, which again, don't forget that BVI companies will tend to be holdcos. You'll get the powers then to also examine directors and examine officers of the company. And if they're in the BVI, a lot of times we describe the nominee arrangements, and that might be a greater use now for nominees, since you can see the register of, since you can see the current directors of a company at any given time. So going forward, that might even be more of an effective tool. But a key thing that liquidation order then allows you to go off and get the appropriate recognitions and reliefs, even on the onshore side. It gets the banks corporations. It creates an entire trail of evidentiary examination, actually. So that, I think, is very powerful, to be honest.
Okay, excellent.
Yep.
Do you have anything else, Judge?
No, that was it. I was just only going to say that I agreed with the rest of the views about the holistic approach when it comes to asset recovery. So all the strategies that we deal with, no matter what, the nature of the sorts of offshore Caribbean litigation that will come through our doors, me based in Singapore, will be, necessarily multi-jurisdictional, and you do have to take a holistic view of your client, of the asset position. Is there, as Reshmi sort of pointed out, a guarantor involved somewhere, and can you go after his assets? Are there family members or low-hanging fruit, as Kumar said? So, I think we're sort of used to dealing with us as being a part of a toolkit of more broader and holistic cross-jurisdictional cooperation.
And just to add to that, I think this triumvirate of investigator, external legal advisors who can think like the client and the client's own strategist, this is an important sort of set of people who each have unique skill sets. And in my view, the most effective asset searches where there's an outcome or we know when to stop or where to go or can change course quickly are the ones where these three parties are talking quite effectively to each other.
Absolutely. Fully agree with that. I think that's often been our experience as well. I'm conscious that we have 2 minutes left, so I will see if the audience have got any questions. If you do, guys, any burning issues or some anecdotes you want to share, please feel free to give in your question through the chat. We'll wait for a few seconds while any questions come through. But otherwise, I think it's been an enlightening chat. I think that the parting message being that.
Sorry for interrupting, Baldeep.
Yes.
I see one question. Will the Privy Council judgment in broad idea affect the power of Singapore courts to issue freestanding phishing injunctions in aid or anticipation of foreign proceedings? This is a real doozy. It's unclear whether or not, I highly doubt that anytime soon we're going to delink ourselves from the requirement of having a cause of action present while pursuing a phishing injunction. I don't see any indication that we're moving in that direction where we're going towards a freestanding injunction. So to that end, other jurisdictions have moved in that direction, but I don't see any indication now, at least in recent times, where we might be going down that path.
It sounds like a lawyer's question, for sure.
Yeah.
My sense of it is I still think the policy reasons tend very much to dovetail your claim together with the injunction at the same in the same jurisdiction, rather than to have a freestanding injunction. I think there might be some real practical concerns in bifurcating it that way, but the BVI has done it, and maybe after some experiences from them, people be more emboldened to do it as well. Guys, it's 6 o'clock. I will have to let our audience go. Thank you for taking part to the audience. If there's any questions you have, of course, feel free to email us. We can address it, and we'll send across some written material and slides as well that we've done over the course of the talk. So in parting note, I'll just echo what Reshmi said, that ultimately the whole job of asset recovery it's a collaborative job between different actors, investigators, on the ground people, your lawyers, and other parties as well. You might have to get specialist experts to look at the nature of the trades and things like that. So thanks to my very esteemed panel today, Jayesh, Reshmi, Kumar, thank you for attending the session. Thank you for speaking and giving us your thoughts. And to the audience, thank you, and I wish you a good day.
Thank you.
Thank you.
Thanks everyone.